Court is back in session at cause number 325897. The case is styled the state of Texas versus Chris Frank Polanco. Let the record reflect that Mr. Polanco is present in court with his attorney, Attorney Ralph Kimmler. State is present with Assistant District Attorney, Attorney Tom Coleman. Let the record also reflect that the jury panel is back in the courtroom. State, are you ready? Defense, are you ready?
That's ready.
At this time, ladies and gentlemen, our court coordinator, Ms. Trina Redmond, is going to call some names. When she calls your name, please have a seat in the jury box, and our court bailiff, Mr. Porter, will hand you a badge. Ms. Redmond, you may go forward.
Good afternoon. When I call your name, please have a seat in the jury box. Michael Joseph Zakar.
Mr. Zakar, would you please follow the instructions of the bailiff?
Alan Dale Kelly.
Mr. Kelly,
Robert Luther Robertson. Fred Edward Enderley. Ella Itza. Gaspar Warren. Daniela Renee Delarue. Pamela Haley Point. Pointe, excuse me.
ladies and gentlemen of the jury, I must administer to you the second of two oaths that I mentioned to you earlier. I need each and every one of you to raise your right hand. And once I finish administering the oath, please say, I do. Do you and each of you do solemnly swear or affirm that in the case of the state of Texas versus Chris Frank Polanco, you will a true verdict render according to the law and the evidence, so help you God? You may put your hand down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions, interpreting them, and how they may apply to this case. You and I have equal authority in this case, but it is divided authority. You are the sole judges of the facts, and I am the sole judge of the law. You are the sole judge of the credibility of witnesses and the weight to be given their testimony. You may believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections. Excuse me. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney or witnesses, or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why the testimony, a document, or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for this, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of the law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her, and the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defense has rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of the case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspaper or watch TV reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. The court has given you name tags identifying you as a juror. Please wear those tags at all times. Now, ladies and gentlemen of the panel, those of you who was not selected, do we have letters? On behalf of the citizens of Jefferson County and behalf of the court staff here in County Court at Law Number 2, we'd like to thank you for taking time out from your busy schedule to come here today. Our bailiff have letters for you, and if you need excuses, he could direct you to the district clerk's office. Now, if you decide that you would like to sit in and watch this case, you can do that. And if you do not have time, if you still like to watch, you can watch it on YouTube. Again, on behalf of the citizens and the staff here of Jefferson County, we'd like to take time out. We'd like to thank you for taking time out from your busy schedules. Now, normally I would shake your hands, but under these circumstances, I cannot give everyone a handshake. However, we'll give everyone an air handshake. And again, I'd like to thank you for taking time out from your busy schedule. You're free to go, everyone. Please have a blessed day. Please follow the bill. Oh, wow. I didn't know that. Hey, are you ready to go forward? And defense, are you ready to go forward?
Ready.
At this time, Mr. Coleman, would you please present the information?
In the name and by the authority of the state of Texas comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the County Court at Law of Jefferson County, Texas, that in Jefferson County, Texas, Chris Frank Polanco, hereafter styled the defendant, heretofore on or about December 25th, 2019, did then and there unlawfully appropriate property by acquiring and exercising control of corporeal personal property, namely a purse owned by Susan Cooper, hereafter styled the complainant, of a value of at least $750, but less than $2,500, with the intent to deprive the complainant of the property and without the effective consent of the complainant, against the peace and dignity of the state.
And Mr. Polanco, how did you plead, guilty or not guilty?
Not guilty.
Okay, you may have a seat.
Thank
And Mr. Coleman, you ready to go forward? You ready to call you? Would you like to have an opening statement?
Just briefly, Judge.
You may go forward.
Ladies and gentlemen, this will be a brief trial, and likewise, my opening remarks will include. I believe that the witness in this case, Susan Cooper, will testify that on December the 25th of 2019, yes, Christmas Day, she with her daughter and two grandchildren were at the Christus Outpatient Center in Port Arthur, Texas, because her grandchildren were experiencing some symptoms. They were ill. They felt ill, so they thought they'd take them to the outpatient center on Christmas Day. Between the grandkids and filling out paperwork, Ms. Cooper will testify that she just forgot her purse out in the waiting area when they called her back. And when she realized that she didn't have her purse, and she went back out to look for it was not there. She'll testify that she had at least a brief encounter where she'd observed the defendant in the waiting room. She'll also testify that she had a conversation with another person who was in the waiting room. She made a determination that quite possibly the defendant, Mr. Polanco, had taken her purse. She used the locator app on her iPad to find her, it's called the Find a Phone app, I believe, to try to locate her cell phone, which was located in the purse. And it pinged or gave a location at a nearby La Quinta hospital, La Quinta hotel. And she made her way to the La Quinta, where the staff there allowed her to view surveillance video. And on that surveillance video, I believe Ms. Cooper will testify that she saw the defendant's image there on the surveillance video. Even more than that, I believe the evidence in this case will consist of a surveillance video from the Christus Outpatient Center there in Port Arthur. And on that surveillance video, you will actually see Ms. Cooper walk in with the grandkids, place her purse on a seat next to where they were located, and forget that purse, walk away. The defendant would come in, subsequently come in after her, and pick that purse up and walk out with the purse. At the conclusion of this case, based on the testimony of Ms. Cooper, based on the evidence, including the surveillance video, I'll ask you to return a verdict finding this defendant guilty of the offense of stealing Susan Cooper's purse on Christmas Day, I think, 2008.
Mr. Kimberly, you'd like to make an open statement? Or you observe? Okay. At this time, Mr. Coleman, would you like to call your first witness?
Yes, Your Honor. State calls Susan Abbey. All right. Abbey.
Susan Abbey. Miss Abby, would you please raise your right hand? Miss Abby, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Miss Abby, you may put your hand down. Miss Abby, you can take a seat on the witness stand. Our bailiff is covering the mic, and you can adjust the mic and the chair.
I proceed, Judge.
Ms. Coleman, you may proceed.
Good afternoon, Ms. Abby. Could you please state your full name for the court reporter?
Susan Abbey.
And back in 2019, what was your name?
Susan Cooper.
And you've since gotten married,
Yes.
so it's no longer Cooper, it's Abby, correct? And I'd like to take you back to, well, where do you reside?
In New York.
And what do you do for a living?
I run a snow cone trailer.
Do me a favor, either get close to that mic or pull it closer to you. I want to make sure the jury can hear you. Prior to operating the snow cone trailer, what did you do?
I was a customer service manager for Hockey Park.
And your family, do you have any children, grandchildren?
Yes. I have grandchildren and two children.
How many grandchildren?
5.
I'd like to take you back to December the 25th of 2019, Christmas Day of 2019, at around 7:50 in the afternoon, in the evening, actually. Where were you?
I had taken my grandchildren because they were at the outpatient center.
Is that the Christus Outpatient Center in Port Arthur, Texas?
Yes.
8801 9th Avenue,
Yes.
and Port Arthur, Texas, located in Jefferson County, Texas.
Yes.
And why did you take them there?
Because they were sick.
And what are their ages, if you could recall, at the time? About,
7 and 5.
and it was you and your 2 grandchildren, did anyone else, accompany you there to the outpatient? And how you were there, did it make you fill out any paperwork, or anything once you got?
Yes. I feel that hopefully.
What, if anything, did you bring with you to the outpatient center?
I had my purse and I had another bag that had their insurance information and things like that on it.
Some point, did you put that first down?
Yes.
Do you recall where you put it?
It was in my chair.
And at some point, did you see someone here in the courtroom today that you observed that day in the outpatient center?
Yes.
Who do you, well, could you please point to that person and identify that person by an article of clothing that they're wearing?
A tan shirt.
Your Honor, I ask that the record reflect that the witness has identified the defendant.
The record so reflect.
And describe for the jury the manner in which you came to observe or come into contact with the defendant.
We had filled out the paperwork and we got 5 rooms that we were admission. But we were sitting in there and I heard a noise, didn't know what it was, but I noticed that the lady that was admitting us was kind of looking outside. I turned around and there was a glass window that was, you know, you could see out of the office. And I saw a security guard come in and then I saw the gentleman at the window picking up a form to fill out, I guess, to see a doctor.
And we said the gentleman, you're talking about the defendant,
Yes,
Chris Frank Polanco.
yes.
At some point, did you make a realization? Or let me ask it this way, did you forget something?
My purse.
And where were you when you realized you'd forgotten your purse?
Well, after I walked out of the office, I kind of said, where's my purse? You know, and I kind of started looking and I looked back in the office and I hadn't left it in there and it was gone.
And what did you do next?
I went out to my car to check, to make sure it wasn't left in my car, but it wasn't.
Was there anything of value in your purse that day?
I had cash money in there. It was Christmas Day, so I had my grandkids' Christmas money that they had gotten. I had my glasses.
How much, I'm sorry to interrupt, but how much cash are we talking about?
Around $280.
In the purse itself, about, what kind of purse was it?
It was a little black purse.
So we got $280 or thereabouts for your kids' your grandkids' Christmas money. And then the purse itself, what was the value of the purse?
Anywhere from maybe $200 to $300.
Any other things of value in that purse? What about a cell phone?
I had a cell phone. I had my glasses.
Let's talk about the cell phone. What's the value, or what was the value of that cell phone?
Probably around $700 or so.
What kind of phone was it, if you recall?
It was an iPhone 7 Plus.
iPhone 7. Now, aside from, well, did you have anything else in there? For instance, credit cards or driver's license?
I did. I had my driver's license, my debit card, my husband's debit card, credit cards.
Now, aside from the things that we would, ordinarily assign value to, were there other things in that purse that, you can't necessarily put a price on?
My cell phone, we had spent Christmas Day with my mother. And we had pictures with my mother and her grandchildren, her great grandchildren. We didn't, of course, know at the time that January she passed away unexpectedly. So all the pictures that I have of my mom and our last Christmas with her were gone. They were in my phone.
Did you contact law enforcement?
Yes, I did.
And prior to contacting law enforcement, let's back up. Did you speak with anybody or anyone else who was in that waiting room that day?
Yes, I did.
And without talking about what they told you, because that would be hearsay, did you form an opinion as to what may have happened to that purse?
Yes, I did.
And what was that opinion?
That it was, he walked out with my purse.
He being the defendant. Contacted law enforcement?
Yes, I did.
Made a report with law enforcement?
Yes, I did.
And did you, on your own, take any steps to try to locate your purse?
Yes, I did.
What were they?
After I got home, of course, I couldn't sleep, so I ended up getting an iPad and tried to figure out how to use find my iPhone app, and my iPhone pinged at La Quinta Inn in Port Arthur.
And by ping, you mean it would
It showed
indicate
up on a map where my cell phone was located at that particular area.
and what, if anything, did you do as a result of that information?
I notified my daughter and my brother, my son-in-law, and they went over to the La Quinta Inn to try and see if my purse was in a bush, or, like he dumped it or whatever, and they couldn't, of course, find anything.
And did you take any other additional steps to
Yes, sir.
to locate it?
The next day, I went to the La Quinta Inn, and I did speak with the lady at the La Quinta Inn.
And again, don't tell us what they told you because that's hearsay, but did they allow you to view anything?
Yes,
What was that?
they allowed me to view the surveillance of the night that he was there.
And what did you observe on that surveillance video?
A picture of him.
And what did you do? Did you capture that picture in some form or
I
fashion?
did, I took a picture of it.
Using what?
Cell phone, I had to get a new cell phone.
Judge, may I approach the witness?
Yes.
I'm showing you, I guess I need to mark it first. Showing you what's been marked as State's Exhibit number 1. Do you recognize that?
Yes,
What do you recognize this to be?
the picture from the community.
The picture that you took?
Yes,
Just for the record, how is it recorded or maintained today? On what device is it stored?
a daddy's good.
Or used, what's also called a USB drive? Have you reviewed the photo that's on this USB drive? When was the last time you looked at it?
Okay.
And is it a fair and accurate depiction of the person that you captured on the photograph back on December the 25th, 2019?
Yes,
Judge, at this time, I'd offer states one, just to the record.
I would object to being on the USB. If it's a photograph that they're offering, it would need to be authenticated. The actual photograph that they're offering before it would be admissible.
I think the photograph is on the USB, that's what he said.
I don't know what's.
I'm happy to
Yeah.
plug it into my laptop and provide, allow inspection by defense counsel before.
Okay,
We do it without it being published.
Sure. Sure.
okay. So let's, oh, you're gonna be on your laptop, okay.
Yeah, approach the witnesses.
Yes.
So Abby, I'm showing you this. Little record, I have placed the USB drive into my laptop and contained on that USB drive is a photograph. Do you recognize that photograph?
Yes,
What do you recognize that photograph to be?
as the photograph from the museum. I do still have it on my phone.
And again, is this a fair and accurate depiction of the photograph from that day?
Yes,
No alterations or deletions?
yes, sir.
Your Honor, for purposes of the record, I'm tendering my laptop with the photo for defense counsel for his inspection.
Ask you, take on board now for a moment.
Yes,
Man, you don't have any personal knowledge of when State's Exhibit 1 was taken at the La Quinta Inn, do you? How it was obtained at my La Quinta Inn?
They
You have
have-
no personal knowledge of
No,
that. Then I would object, Your Honor, that it hasn't been sufficiently authenticated as being what it purports to represent. That would be a photograph of the defendant at or near the time of the occurrence of the offense. This is simply a photograph obtained by this individual from La Quinta Inn, not taken by her, of what purports to be the defendant at some general time, not necessarily relevant to the time period in question here. I don't think that she's in a position to authenticate this photograph for the purposes of being admissible.
Mr. Coleman,
Your Honor, her testimony is that this photograph was taken the day after the alleged theft in a location where her find a phone app would put her cell phone. She is testifying, or would testify again, that this is the same individual that she saw at the outpatient center.
She doesn't have any personal knowledge of when that photograph was taken by La Quinta Inn. She just said that.
And Mr. Kilmer can certainly cross-examine her on it, and the court can admonish the jury about the proper way to give this
That goes to the
evidence.
That goes to the admissibility of the photograph as far as properly authenticating the photograph to being what the state purports it to be. The state is offering this and purporting this to be a photograph of the defendant made at or near the time that the theft occurred. She doesn't have personal knowledge of when that photograph was obtained by La Quinta Inn. In other words, the state is attempting to bootstrap the admissibility of this photograph. The proper way to admit it would be to have the person from La Quinta Inn, where it was obtained, authenticate the photograph as to date and time. She's not in a position to authenticate it to date and time. That's what they're trying to bootstrap that on. She can testify, I suppose, that she obtained it on her phone from La Quinta Inn, but that doesn't establish when La Quinta Inn obtained the photograph. That's what they're attempting to do.
Judge, at this
Okay.
time, I will withdraw my offer of state's exhibit 1 at this time.
okay, you may go forward,
Ms. Abby,
and you just can sustain.
nevertheless, you viewed that video, correct?
yes,
And you saw an individual that looked like the defendant on that video.
yes,
Now, now,
Yes. Yes, ma'am.
Judge, at this time, I'd offer state's exhibit number 2, pursuant to a business record affidavit under Texas Rules of Evidence, chapter 803. For purposes of the record, I am tendering state's exhibit number 2 to the defense counsel. The business record affidavit has been on file, with the clerk and has been served on defense counsel for the requisite period of time.
Can I see the affidavit? I would make that this isn't a business record affidavit. This is surveillance video that needs to be authenticated by the person that has knowledge of what it purports to be. It's not a business record, it's surveillance video.
Judge, in response, it is a business, maintained in ordinary course of business by the outpatient center there, and even more than that, the defense counsel, it should have, according to the rules, objected within a certain amount of time for trial if he objected to the use of that business record.
I'm not objecting to the extent that the state does not follow the prerequisites for attempting to introduce this as a business record. I'm saying that this is not a business record. This is not the record of a regularly conducted activity of a business under the hearsay statute. This is photographic evidence that the state is required to independently authenticate as being a fair and accurate representation of what it purports to represent. They're attempting again to circumvent the requirement that photographic evidence be authenticated in the manner prescribed by the rules of evidence, which means a person with knowledge of what it purports to be comes in and testifies that it does represent fairly and accurately what it purports to represent. Attempting to qualify that as a business record to circumvent that requirement is improper, and I object that this is surveillance video that they need to authenticate by somebody that has personal knowledge of the video record.
I stand on my previous argument, Judge. It's a business record affidavit, and we've done what we needed to do to properly meet the prerequisites to for its admissibility.
They could have subpoenaed the proponent of this from Christus.
I know
The
what
facility is coming and authenticated as surveillance video, just like a photograph from the keeper.
I'm sorry, I interrupted, Mr. Chairman.
You gotta-
The standard is not what we could have done, but what we are legally entitled to do. We're legally entitled to introduce that video as a business record.
It's what they're required to do, and they're required, again, authenticating a photograph or video surveillance. This isn't an uncommon occurrence here, how it's done.
Right. Now, Mr. Kim, are you stating that it's not a business record because it's a surveillance?
I'm saying that even if, I'm saying it's not a business record as surveillance video, it possibly could be, but still there's an additional requirement that if you're the proponent of this evidence, that you have a person come in to sponsor it to say that it fairly and accurately represents what it purports to represent.
That's what you had the business record affidavit.
And that's what it's sworn to in the affidavit, yes, sir.
It's not a business, it's not a record of regularly recorded activity of a business, Your Honor, it's surveillance video. It's not like accounting records or some type of employment records or something like this. This is surveillance video, like a photograph that needs to be authenticated the way photographs and surveillance video are authenticated. That is by having a person come in and testify that it fairly and accurately represents what it purports to represent and be subject to cross-examination about that.
Okay, I will overrule your objection.
Again, I'm going to object that it violates his right to confront and cross-examine witnesses as well, Your Honor. Allow this in without a proponent.
Okay.
Question about the veracity of what it alleges to depict.
Okay, well, it's overruled.
It states, exhibit number 2 admitted that, Mr. Judge.
Yes,
May I post it for the jury?
yes. Let me see the affidavit.
I'd observe also, Your Honor, it appears to have been filed less than 30 days from today's date. Don't know that it comports with the time frame either. So I'd lodge additional objections as follows.
Okay. Yeah, before you,
Because I believe the requirement is 14 days prior to trial.
Well, just to be clear, Your Honor, not objected, it hasn't been timely filed. With this trigger, it hasn't been timely filed as well. Which basically,
okay, where's the requirements I'm looking for? It says 14. Oh, before you do that. like it was filed on November the 29th.
That's what it appears in the corner.
Yeah. And I think it's, when it's e-filed, it's e-served as well. Is that
That's
correct?
right.
It has to be accepted. I mean, that's all that process with e-file. You e-file it, it has to be
It
accepted,
was accepted,
but it's not accepted as soon as it's e-file. It can be,
but it was accepted.
I don't know if it was or wasn't, but.
I represented the court that it was.
I mean, was it accepted on November the 29th?
No.
That's what I'm saying. You're saying, when was it?
My,
It says-
my recollection is it was accepted the same day it was filed.
That, they don't ever accept it the same as.
They just-
It's an original copy
Yeah,
of
we
the
went
record
around.
meets the requirements if the record is accompanied by an affidavit that it complies with the subparagraph of the rule and other requirements.
I don't know if the rule
Served.
that should be measured from this. E-file with the date it's accepted for e-file
The
as
day it
well.
was filed.
For good cause to court. The proponent of a record must serve the record and the accompanying affidavit on each other party to the case at least 14 days before trial.
Which was the case in here.
Yeah.
And again, I don't know, again, I
I mean,
can't
it-
represent that I was served with that. I don't want to say it wasn't because.
The record and affidavit may be served by any method. Okay.
But I wasn't served with the USB, I can tell you that.
Oh, well, this is, okay. Okay, yesterday was the 14th day before trial.
That's my calculation.
Okay. And so, do you have any evidence that you weren't served?
I can't say that I was served. I'm not saying that I wasn't. I don't know that I was.
Okay, yeah, so you didn't check your email?
I've checked my emails. I can't recall being served with that. I'm not gonna represent that I wasn't, but I can't recall being served with it. Yeah, unless he can prove, I mean, electronically should be reflected. in-
I see an e-file,
Whether it's been served or not.
it said file for record on this date, November the 29th, 2022 at 10:01 a.m.
I know there's times when I file things and I neglect to serve them with it. So it's not
Well, I don't-
automatic that the opposite party gets served once just because it's emailed. Because I've been remiss in doing it myself.
I represented the court that on that day that I filed it, that I got a notification that Mr. Kendall was served on his email and that the clerk's office accepted that file. That's what I represented the court.
Okay, so that is, your objection is overruled?
Permission to publish state's exhibit number 2.
Yes.
Hey, thanks for giving that. Yes. Abby, what are we looking at here? Can we dim the lights maybe just a bit? That's possible. And if it's easier, it's being displayed on the screen behind you there.
Okay.
Ma'am,
Yes.
David, do
That's easy.
it. Oh, all right. What's depicted on the screen, Miss Abby?
That's the waiting room of the Christus Outpatient Center,
And,
and those are my grandchildren.
okay. Who's this here?
That's me,
And who's this?
that's my daughter,
All right. What do you have in your hand?
the registration forms.
I can run it back just a bit here. I think I may have missed something. It appears that there's an object in your hand there. What is that?
That's my purse.
Okay. And start the video again and please describe to the jury what you do with that purse.
I set it in the chair.
What are your grandkids' names?
Presley and Chandler.
Is this Presley
Yes, sir.
and that's Chandler?
Chandler.
What's happening now?
They called us into the reception area.
Where's your purse at this point?
Sitting in the chair.
Who's this individual that just appeared on the screen?
Mr. Blanco.
The defendant in this case?
Yes.
Is this the security guard that you testified about earlier?
Yes.
And again, your testimony was that the security guard, what was going on there?
I'm not sure exactly, just that the security guard told him he had to fill out the paper. And showed him where the little desk was to get the papers on it.
And is this where you observed him?
Yes.
About how far away were you from him, if you had to estimate?
Maybe from here to the court reporter.
Now, there's other people who come into the waiting room, right?
Yes.
Let me pause it here. After your purse went missing, did you have an occasion to talk to any of the other individuals in in the waiting room about what happened to your purse?
Yes, sir.
Did you talk to this individual?
Yes.
And just for the record, how is she positioned? Would she be in a position to have seen what happened to that purse?
Yes, she was facing my purse.
Oh. What just happened?
He picked up my purse and was walking out the door.
Let me run it back again. It happens pretty quickly. What is this in his hand there?
My purse.
That's all I have for now on the street. Did you, give law enforcement a written statement that day or
Yes.
close to that time?
Yes, I do.
Have you testified consistent today with what you reported to law enforcement and what you included in your written statement to law enforcement that day?
Yes,
Did you give the defendant, Chris Frank Polanco, permission back on December the 25th, 2019, to walk out of that outpatient center with your purse?
no, I did not.
Judge, I'd like to put State's Exhibit 2 to the court order, and I will pass this.
Gets the affidavit.
Oh, that's my copy. If I can have it back. It's, a copy is on the file in the clerk's room.
Mr. Kimler, you may proceed.
What kind of purse was that, did you say?
Was that coach purse?
Coach? And did you acquire a gift?
Yeah.
Where
It was a
from?
gift.
Oh, was it a
It
gift?
was a gift.
So you're not familiar with what the purchase price was for it?
I have other coach purses, so I know the price range on the coach purses. And this one was probably $200-300.
So the purse itself was $200 or $300 maximum.
Yes,
Never recovered the purse.
no, I did not.
Law enforcement never recovered
No.
the purse.
No.
Your knowledge, there's no law enforcement presence to testify today for, or any police officers you may have spoken to? Or anything like that? That's what it's.
Okay.
Mr. Abbey, just to be clear about the value of the purse, you're personally familiar with, I mean, in your day-to-day life, with what those coach purses go for, right?
Yes,
I mean, have you owned designer purses in the past?
yes,
Have you worked in the retail field or associated with the retail field in the past?
yes.
So based on your personal knowledge, what is that, what is the value of that purse?
$200-300.
That's what it's.
Nothing from.
Okay. Mr. Coleman, may this witness be excused?
Yes, if she could step down.
Defense? Yeah, may she be excused?
Yes.
Okay, Mr. Abbey, you may be excused. You can follow the bailiff. You have a blessed day.
Thank you.
Judge, the state has no further witnesses and the state will rest at this time.
I have a motion to present, Your Honor.
Okay, ladies and gentlemen of the jury, would you please step outside? There's a matter that needs to be taken up outside of your presence. Oh, let me take the